charity merger means putting two or more charities together into one, whether that one is a legal entity or whether it is a group of charities. And the way you do it depends a lot on the circumstances and the nature of the charities themselves, whether they are in fact companies or unincorporated trusts, for example, or associations. The end result can be therefore either one charity with everything in it, one vehicle with everything in it, or it can be a group with one with various different roles, including running the other. Charities should consider merger because it is part of the regular review that charity trustees should always take in the life of a charity. Because the world moves on, and just because the way you did it previously feels comfortable does not mean that it's right or appropriate or that you're getting the best out of your charity. You should always be looking to see how you could do things better. That is a duty of a charity trustee. As part of that, you may consider some alternatives. It doesn't have to be merger, of course. It could be a collaboration, or it could be an agreement, a joint venture with another charity or another organisation, which helps you do things more efficiently, gets advantages from the sharing the cost and so on, and that is commonly done. But merger, as we have seen, is a more radical commitment. The important thing about a merger is that 1 and 1 must make 3. If 1 and 1 makes 2, then you run the risk of merely making 2 inefficient charities one large inefficient charity. There are various risks to run, but the advantages are normally that if you get it right, then you have more beneficiaries, you have a bigger choice of trustees, and skilled trustees are always in demand, and you have an ability to cut cost, which can make a radical difference as to how much you've got available to spend on your beneficiaries, which is why you're there.
David Cameron's vision of the big society might be a distant memory, but charities have always interacted with the public sector and will continue to do so for as long as charities exist. Comparisons are being drawn between the collapse of the construction giant Carillion and charities that provide public sector contracts. So although they're very different industries, some of the features that led to Carillion's collapse also apply to charities when they're undertaking public service contracts. So things like underpricing and short-term funding, all the unsustainable pensions liabilities, and risk exposure, payment risk exposure. All these factors are things that Carillion suffered from and therefore ultimately led to its demise, and they're also things that the charity sector has wrestled with for years when they're entering into arrangements with the state to provide public services. So when entering into public service contracts, charities firstly need to have a very clear rationale for why they are entering into the arrangement. Why will it benefit their beneficiaries, and why is it in the best interests of the charity? And when they've decided that it's something that the charity should do, then they need to document those decisions very carefully. Charities must make sure that they negotiate contracts with public sector authorities. Public sector authorities often present these contracts as non-negotiable, but every contract should be negotiable, and if the public sector authority is unwilling to do so, perhaps questions should be asked at board level about whether or not you should enter into these kind of arrangements. So look at what others are doing. Are they doing it better than you? Would you be better off working together, maybe to pitch for the services or to provide them? And you may be able to collaborate through a contract, or you may prefer to eventually merge if bigger means better, and better services can then be provided for your beneficiaries. You'll then potentially benefit from economies of scale and also share the risks. Think carefully about your payment terms. Will you have enough liquidity to enable you to provide the services? Will you be leading a hand-to-mouth existence? And if possible, negotiate the contracts so that you'll be paid in advance rather than in arrears. Check that there is actually certainty that you will actually be paid for the services that you have provided. Sometimes in public sector contracts, payment itself is not at all certain.
The possibility that there be a new Charities Act started when the Charity Commission identified a number of legal problems charities were facing that it thought would benefit from review. This was followed by Lord Hodgson, who undertook a review of the Charities Act 2006, and he also identified a number of legal problems that he thought the Law Commission should investigate. The main purpose of the proposed changes is to remove unnecessary and inefficient regulation so that charities can make better use of their charitable resources. At the same time, it's clearly important to make sure that the necessary safeguards are in place to protect public trust and confidence in charities. The report produced by the Charity Commission was over 370 pages long, and there were 43 main recommendations. To pick up on a few areas of key recommendations, firstly, land disposals. The aim is to provide charities with greater flexibility and to enable them to seek advice from a wider range of professionals when considering land disposals. Secondly, changes to governing documents. The aim in this case of the reforms would be to remove inconsistencies and provide a better procedure for unincorporated charities. Thirdly, mergers. The aim is to remove barriers to mergers between charities. And lastly, permanent endowments. The aim in this case is to provide greater flexibility whilst at the same time protecting endowment funds for the longer term. It's currently unclear when the Charities Bill might become law. The draft bill was included in the report produced by the Law Commission, which was published in September 2017. The government has yet to respond, but it's hoped that, given the extensive consultation that was done before the report was published, that it will be favourably received. Once the government has responded, the next step would be for a draft bill to be introduced into Parliament. Because of the lack of parliamentary time as a result of Brexit, it's currently unclear how long it would take for the bill to pass through Parliament.
When I'm asked what charities and indeed any business should be doing for GDPR, the first thing I say is that they should be doing something. If you haven't started preparing, then you need to start doing so now. This regulation isn't going anywhere. So in terms of how to prepare, well, like many areas of business and life, you should have a strategy in place. And part of that strategy for GDPR compliance should be thinking about it in a staged way. You can't eat the elephant all in one go. In terms of those stages, well, the first thing businesses and charities should do is to have an idea as to what data processing they are doing, what data they're collecting, who they're sharing it with, how they get rid of it at the end of that life cycle. In putting together that document, you don't need to take a forensic approach to that, and it certainly shouldn't be at the expense of putting other more practical compliance steps in place. So for those practical compliance steps, well, take your pick. Businesses need to sort out their policies, they need to think about the contracts and the information they're providing to individuals. But I always say that one of the first practical steps should be thinking about sharing data, because that changes the risk matrix when data is leaving your organisation. So if you're sharing data with a third party, have you got the necessary protections in place in order to ensure that what they're doing with that data is legitimate? If it's subject to a legal document, does that document contain the necessary protections? In terms of the difficulties charities are facing with compliance with the GDPR, well, when you look at it through the prism of being a compliance exercise, it can be somewhat overwhelming and it can be potentially very expensive, particularly if you're focused on the deadline, the 25th of May, when the regulation comes into force. It can be expensive financially, if you need to consult third parties, if you need to bring in auditors, consultants, lawyers to help you with the compliance exercise. Or even if you want to take more of a hands-on approach yourself, it can be expensive as a time exercise if you need to invest the time in getting to know this regulation. But I'd encourage charities and all big businesses to look beyond this, to think of this not just as a compliance exercise, but a commercial exercise. You want to be able to demonstrate to people that you're taking this opportunity, the GDPR coming into force, to ensure that what you're doing with data is responsible and that individuals can trust you with their data.
Poor fundraising practices in the charity sector have been in the news quite a bit recently. The sector itself is no stranger to public scrutiny. Over the years, many questions have been asked. For example, why doesn't all my money go to charitable good causes? Why do charities have to spend on admin? All these type of things, because the public have a very high expectation of charities and they almost expect them to behave better than they do themselves. And the focus on poor practices in the fundraising arena really arose in early 2015 with the death of Olive Cook, a passionate and devoted charity donor who took her own life following enormous pressure for donations to be given from multiple charities. And that focused public attention, followed also by other scandals such as the Neat Feet scandal, where other fundraising activities by a fundraising agency were brought into the public scrutiny, and they were doing all sorts of cold calling and other pressurised techniques, very often targeting vulnerable people that didn't know how to say no. And so the government asked for an independent review, and Sir Stuart Etherington undertook this in the middle of 2015, and his conclusion was that there should be an independent charity regulator, a single regulator in the fundraising arena, and these recommendations were accepted by the government. And really it has to be viewed as drinking at the last chance saloon for the charity sector, because if they don't self-regulate, then the government will put in place a statute. And the problem with that always, of course, is more regulation, means more admin costs, and that shouldn't be necessary if everything is done correctly. So the fundraising regulator was put in place and started its activities in July 2016, and have really been working on the fundraising code. And this of course does have a huge impact on the sector because there is a regulatory framework that the sector has to work with. The sector has been hit by further challenges and scandals over the last few months, and so faces fresh challenges. However, what I think the sector has realised is that there's no point carrying out absolutely amazing work with the best intentions possible without doing it in the right way. And the challenge going forward is to continue rebuilding that trust and confidence that is so valuable.
Before the event strikes, trustees need to be anticipating, without knowing what it's going to be, but that something could happen, and it could happen at any time. And so you need one point of contact, but because it can happen at any time, that person has to have a number 2 and even a number 3, so that if it's a Sunday evening or over Easter or whenever it may be, there is one person who can respond or not respond, ask for some more time, and then be in charge of collating everything so that an accurate and hopefully complete answer is given in the time that's been allowed, or more time requested, which is a perfectly proper thing to do. When a news organisation contacts a charity, there is a temptation to just seek to deal with the time scale you've been allowed. But in fact, one should look closely at the write a reply letter that you've received. First of all, make sure it's from who you think it is and not a media student or someone out to cause some mischief and make a name for themselves. But having gone over that test, you need to see if there's more information you need before you reply. And obviously, out of politeness and common sense, you should say that you need more information and expect some from them, but in return, that is an indication that you are engaged in a dialogue, and therefore you must, in due course, give your detailed reply, but possibly taking into account the additional answers that you yourself have been able to obtain from what one might think of as, it is sort of one side against the other side, but actually the media should be approaching you about something that is of the public interest. This is very public work done for the benefit of further third parties throughout the world.
The risks for a charity ceasing to participate in a defined benefit scheme really depend on the type of arrangement they're in. The greatest risks are in respect of funded defined benefit schemes, and that's because a shortfall can develop between the pension promised under the scheme and the amount of assets available in the scheme to meet that promise. When a charity ceases to participate, that shortfall crystallises as an employer debt and is immediately payable by the charity. Many charities will participate in funded public pension schemes, such as the local government pension scheme, and that will be as a result of an obligation to do so under the public sector outsourcing contract. An employer debt can be triggered in those circumstances when the contract comes to an end or when they cease to employ active members in the scheme. That debt liability is immediate and it's down to the administrator of the local government pension scheme to call it in, and they can agree a deferred period over which to do it. But really at that point the charity is at the whim of the local authority as and when they need to pay that debt. The key thing for a local government pension scheme is that it's open to charities to negotiate the terms of their participation before they join. And that can include an indemnity against the employer debt, so taking legal advice really is essential for charities in those circumstances. For charities that participate in multi-employer industry-wide pension schemes, the issues are the same, and that particularly an employer debt can be triggered if they cease to employ active members in that scheme. For that reason, many charities are now locked into these multi-employer defined benefit schemes, continuing to accrue defined benefit pension liabilities because they can't get out without triggering that employer debt. The options for charities with their own private funded defined benefit pension scheme are equally limited. Many of them will be looking at ceasing future accrual in the scheme, so not offering defined benefits to their employees going forwards. In that instance, they'll have to look at the employment contracts to assess those risks and check the pension scheme rules to ensure that they don't inadvertently trigger an employer debt. In terms of dealing with that employer debt, the options are: one, to find another charity or company that are willing to take on that liability, or to continue to fund the scheme effectively until they can get it to a level where there's enough assets for them to buy out the liabilities with an insurance company. Many charities will also be participating in unfunded public pension schemes such as a teacher's pension scheme, a civil service pension scheme. In those schemes there isn't the risk of the employer debt, and that's because the government effectively underwrites them, so if there is any shortfall the government will meet it. However, they may want to bring an end to their obligation to contribute to that scheme for their employees, and contributions can be as high as 20 or 30% of an employee's salary. But before they do so, they have to carefully check the terms of the outsourcing contract, because that will ordinarily contain an obligation to provide defined benefits to their staff. And if they cease to do that, then they're at risk of breach of contract, which of course brings with it the risk of claims and costs.